Hello, Internet, and welcome to the 49th episode of the Deep Fried Neurons podcast. Today, I got you a very special guest, Professor Mahesh Deshpande, and he's one of my favorite teachers. You'll get to that when we're in the recording. He'll introduce himself, and you'll understand why he's such a special guest on this podcast. And to be honest, it was very cool of him to do this podcast with me. Also, that I've been working my ass off this week because I've had time to make episodes, making sure that you guys get weekly content from this week onwards. Every Wednesday, one episode will be added to the catalog. And I apologize, my washing machine's crying right now. I think its PTSD is acting up. It has never been the same since it came home from the war. So, yeah, that. And, I might get the episode numbers wrong in the recordings themselves because I planned to release some later, but I then changed my mind about them and things like that. Also, a warning about this episode is that it's a little cringe. I tried to talk to Mahesh sir about memes and I didn't really go anywhere with that, but I'd be lying to you if I told you that I'm never cringy. So I just kept it in the recording. Also, I'm very lazy. So bear with me with that. And, I'm gonna cue the fucking... Hello, people. I think it's the 51st episode of the Deep Fried Neurons podcast. And today we have a very special guest with us, Professor Mahesh Deshpande. I believe he would be more comfortable in introducing himself on this podcast because I'm not sure where he did his qualifications from. So,
Okay.
Introduce yourself.
All right. As Anuj has said, my name is Mahesh Deshpande and I am a doctor of medicine, and now I have diverted myself into study of law, and presently I am pursuing my PhD in criminal law. And I am teaching criminal law to my undergraduate students as well here in Symbiosis Law School, Pune. I spent 5 years in the Indian Army as a medical officer, and then I pursued my post-graduation in pediatrics. After practicing for a number of years, then I thought I need some diversion, and so I pursued my interest in foreign languages, and I did my Master of Arts in French language, and from then I diverted to law. I completed my LLB in 2013, LLM in 2014, and from 2015 onwards, here I am in Symbiosis Law School.
That's the answer to the question, who do you bring home to your parents? So Mahesh sir is a brilliant teacher and he's my favorite professor so far since I've joined law. And I really wanted to get his opinion on something that we like to discuss on this podcast, capital punishment. So that's the broad theme today that I wanted to explore as to what you think capital punishment is, and in what cases is it applicable. One of the things we'll be discussing is, of course, rarest of rare principle. So far, my conception of capital punishment has been that suppose an individual has done a crime so heinous that there's no coming back to society after that, to the extent that he must be killed in the common good of everybody. It's the last alternative that we can't really take. We're not really excited to take, but we dispassionately have to, because that act is too heinous for us to forgive. Is that where Indian judiciary is likely to come from when they give the order of capital punishment?
Well, the topic of death penalty or capital punishment is age old. And since time immemorial, I would say that murders have been known in the history of mankind. And the philosophical approach to that was blood for blood and eye for an eye. But that is being misconstrued of late. And since taking away a human life is the most heinous crime that a person can do or a human being can do, the sanction, the punishment had to be equally severe in the form of taking away the life of the murderer. That has been the traditional thinking, and it has been in practice from, as I said, time immemorial, starting from ancient civilizations. To give one example, during Roman era, killing your father was the most heinous crime, which is called as a parricide or patricide. And the person would be kept in a bag, I mean the convict, the son, kept in a bag with a snake or some such wild animal, and then thrown into the river so that he dies a most horrific and painful death. Now, we wonder as to what kind of horror was being inflicted. But we must understand the reasoning 2000 years ago that Roman society was a patriarchal society, and what was called as pater familia. Pater is father. So, in those days, 2000 years ago, the father was the head of the family. Not only that, he was the lawmaker, and he would lay down the law for his own family. And any infringement or violation of that law would invite severe punishment from the father himself. So that kind of status the father used to enjoy, and therefore if you compare it with a sovereign, in natural law theory we say that the sovereign is the person who gives you the law, and therefore if you compare in those days father with a sovereign, it amounted to killing a sovereign, killing your own father, which was like an offense against the state, which was a high treason. And so if you can appreciate the severity of that crime, the punishment had to be equally severe.
Yeah, it was questioning the highest form of authority in the familial structure.
That's right.
And hence, like, familial structure is elemental to society.
Yeah.
It was an offense against society that was the biggest of its kind at the time.
Yeah.
Okay.
So, therefore, you will see that death punishment has been there throughout millennia. But modern day penologists, they are thinking on different terms, and those terms are such that a murderer should not be again put to death, because the state must not commit a murder. The penologists look at death sentence as murder sanctioned by the state, and therefore two wrongs don't make one right. The penologists are advocating reformation as the only basis for punishment. No matter how serious the crime is, one must give, the state and the judiciary must give a chance to that offender to reform himself. That is the idea behind not awarding death penalty in most of the jurisdictions across the world.
I mean, that's the difference between a penitentiary and a correction center.
That's
is
right.
what I'm hearing.
That's right. Yeah.
So this is where my perspective comes in, because I read about this judgment called Bachchan Singh.
Yeah, Bachchan Singh.
Yeah.
Bachan. Bachchan.
Yeah,
Bachchan Singh versus State of Punjab. Yeah.
Yeah, the one where rarest of rare
principle was evolved. Yeah. Yeah.
So I thought that was a good negotiation for to navigate these waters, because while I agree that a chance to reform oneself is important, I believe that the state also needs to be efficient as to what extent is reformation even possible or worth investing into for an individual.
Yeah.
I generally believe that a state's job is to ensure autonomy to the individual, but at the same time, how much consequences should the entire society bear for the same state? So could you, in brief, explain our audience what the rarest of rare principle is?
Yes, certainly.
Thank you.
The principle of rarest of rare was formulated or evolved in a landmark judgment called Bachchan Singh versus State of Punjab. Those of the listeners who are studying law or who have studied law, for them I'll quote the citation, which is 1982 SCC 684.
I should tell our audience that he remembers that. He's not reading this off of a paper. Go on, sir.
So, this is a very famous judgment, and every law student, according to me, must read the judgment, and not only that, must remember the citation as well. It's very handy to remember such citations. Now, a constitution bench that is comprising of 5 justices of Supreme Court of India, they heard this case, and the issue before the court was on 2 prongs or other. One was the very constitutionality of death penalty, and Articles 14, 19 and 21 were evoked as to the violation of these articles. The death penalty, the very idea of death sentence is going to invite, and therefore it is unconstitutional on these 3 grounds. And the second issue was about whether death penalty should be used frequently, or whether it should be reserved for only special cases. So on first count, the court said yes, it is constitutional, there is no doubt about it. Now on the second count, the court agreed that death penalty is such a severe sanction, it is irrevocable and irreversible, and therefore it must not be used commonly. So when should it be used? So the word used the expression, the court used the expression rarest of rare. Now what does it mean exactly? Now nowhere it is defined what is rarest of rare, because the law, that is the statute law, does not use these terms, but it is the case law, Bachan Singh notably, which is using this term rarest of rare. And for that the court laid down certain conditions, saying that first of all they described the murder, because remember that the court was discussing death penalty for murders only. And after this judgment, all murders under Indian Penal Code were clubbed together for death penalty. And in that situation, the court laid down that although we agree that all murders are cruel, but the cruelty varies in its degree. And when it approaches the extreme degree of cruelty or culpability, it becomes depravity.
Oh.
So court laid down the cruelty to culpability to depravity, establishing a link, logical link. So only in such where depravity is obvious, that becomes a rarest of rare case. And then the court describes certain 6 adjectives to describe a murder, like gruesome, heinous, dastardly, diabolical, revolting. So these 6 adjectives are for the help of the trial court to decide from the factual matrix whether these 6 adjectives or some of them apply to the given case. So that is one guidepost to decide whether it is rarest of rare. And secondly, the court laid down that the taking away of life through, I am quoting verbatim from Bachan Singh, the ratio, the taking away of life through instrumentality of law should be preserved only in rarest of rare of the cases, because the dignity of human life supervenes over every other consideration. Wow, that was rarest of rare laid down.
It's just what blows my mind is that you remember that. I don't have that kind of memory. And by the way, Parth could be witness to that if anybody's in my class.
Let Parth say something on the interview if he wants to.
Parth, do you want to give somebody a shout out?
So that you are a part of this procedure, witness.
To all the criminals in our class, hello.
Well, to be honest, like not to go off on a tangent before we get on the capital punishment, which we take very seriously, I generally assure my audience. This is a shameless attempt to like reel in my class's audience, because not a lot of people listen from our class to my podcast. And we know that Mahesh sir is a celebrity professor. So we were like, definitely, people are going to tune in. Anyway, beyond that, another parallel that I saw here is that while there is the rarest of rare principle that helps us establish which case should have the death penalty as a punishment for your crime, and like sir helped us understand that there is degree to how severe depravity is in a murder case, and like not all cruelty is the same. Another place that I saw that murder was mentioned in the very section was section 396, which establishes that a murder during a dacoity is grounds for the death penalty, or at least that's what the section says in like its essence, is what I understood. So how does the court justify that particular statement or that rationale?
Okay. To be honest, IPC has prescribed death. I'm talking only about Indian Penal Code in about 10 different sections, 10 offences, whereas 52 sections are prescribing life imprisonment. And this includes again 302, which is punishment for murder. The point here is that 4 or 5 common offences where death comes to the mind is, one is of course murder. Then another case would be 364A of Indian Penal Code, which is kidnapping, abduction for ransom.
For ransom.
Yeah. So where death, even if the death doesn't occur at times, mere demanding the ransom will invite death penalty. That brings us to another topic called death penalty in non-homicide offenses, but that's apart, of course. And then another offense is 396, which is dacoity with murder.
Murder, yeah.
And then after the 2012 Delhi tragedy of the gang rape and the brutality against the hapless victim, the law was reformed in 2013, and death penalty was introduced as a punishment for rape under 376 under certain conditions. Notably that if death results from rape, then death penalty can be prescribed, can be imposed. Or secondly, if the rape victim's condition results into a permanent vegetative state, in that case also death can be imposed.
Okay.
But coming to your question on 396, dacoity with murder, our audience must realize that dacoity is a very deadly and serious offense. The whole idea is to strike terror in the mind of the victim. Dacoity is nothing technically but a robbery committed by 5 or more people. Robbery itself is quite a heinous offense. So when 5 or more people commit this kind of an offense, it becomes that much more terrorizing. And during dacoity, if a murder takes place, that becomes the ultimate heinous crime, which will come under the category of rarest of rare. And that's the reason behind prescribing death penalty for dacoity with murder.
Which is, I don't know if it's mentioned in, I think we did the story of, what's that dacoit who made it to the Lok Sabha? What's her name? Oh,
The lady, Phoolan Devi.
Phoolan Devi.
Yeah.
So I think during that episode, I came across the same, like Section 96, that she was, while she was negotiating her surrender, one of the things that was considered was her presentation in front of the court and, well, like whether she will be given murder for her massacre during her dacoity days. So that's where I came across this. How negotiable is the judiciary's role in cases like this? Like, that's what I'm curious about. Because I nowhere read a court's judgment when it comes to Phoolan Devi. I read that there was a political surrender, which the CBI negotiated. And it was, I think, the BBC's radio show where I caught most of the details for it. So if a surrender is being negotiated under these circumstances, how much autonomy is judiciary given in determining punishment?
Well, first of all, 2 or 3 things I must clarify. What you are referring to is a Bahamai carnage. Bahamai was the place where she lined up those 28 or 32 Thakurs.
33, I think.
So, allegedly, who were her tormentors, they raped her, etc., etc. She lined them up and shot them dead in cold blood. Now, 396 will not be applicable here because the murder must be carried out during dacoity.
Oh, yeah.
She was not indulging in any kind of a dacoity that time. This was pure murder. This was mass murder, call it whatever. So that is the situation. So let us not bring 396 into discussion at all. Apart from these 33 victims of hers, she must have committed number of murders also. We don't know. We don't have exact data or statistics. Now, if you remember in the 80s, the government sanctioned a kind of pardon to all these surrender to dacoits who willingly surrender. And I think that time the Madhya Pradesh Chief Minister was late Mr. Arjun Singh. And he coordinated and negotiated these surrenders. And they were asked to surrender and to ensure them a normal life, their integration back into the society. I'm not too sure whether they were charged and whether they were tried and whether they were convicted. I think we'll have to dig up information on that precisely. As far as I remember, she was given a pardon. I mean, what were the terms of surrender? I'm not aware, precise terms of surrender, if you are aware.
I'm aware that she was like jailed in MP and she refused to go to jail in UP. That was one of the most important ones. Also, that none of her gang members will be sent to UP or will be in a different jail altogether was another condition. And there was something about of course, death penalty was out of question for all of them, was also one of the conditions. That's all I remember from her surrender. I also remember that she left jail before her term was complete.
Perhaps, no, then I have to raise a question whether she was tried by a criminal court, convicted and sentenced to some imprisonment. Is this the story? Because as far as I remember, she was detained as an under trial.
Yeah, she was not.
She was
sent
never
to trial
tried.
ever.
So another criminal law issue crops up, especially procedural law, as to how long she was detained as an under trial. And was it proper on the part of the judiciary or on the part of the executive to hold her like this? Where investigations carried out, was a charge sheet filed, and if the charge sheet was filed in the court, why didn't the matter go to trial? That is the issue we have to discuss in case we have the record about that case.
I think she confessed to 3 dacoities and the massacre in Bahamai, and I'm not aware of a charge sheet being filed.
Because confession, again, if it is to the police officer, then it is not admissible in the court of law.
Oh, is it?
Yeah, that is Section 25 of Indian Evidence Act, which clearly bars that any confession made to a police officer is not admissible. So you can confess to any police officer to your glory. Court will not take it as evidence.
Okay, you have to confess in the court for it to be considered evidence?
Actually, not in the court, but there is a provision called confession to a magistrate under 164 of CRPC.
Okay.
The accused can make a confession to the magistrate, which will be admissible in the court. Yeah.
I think that's towards the end of our capitalist punishment segment. Just to match the tone of what we were discussing so far, we will get into memes. Are you aware of what memes are, sir? No? Not into the meme culture?
Memes on the net, you mean?
Yeah, memes on the internet.
No, I think I must have seen one or two, but I'm not into that. Please enlighten me on this topic.
So, I mean, because you belong to a generation that memesters on the internet, especially the younger kids, not me, never me, is like to interact with and make fun of on the internet, especially, is why I wanted to get your opinion on it, because I think it's a culture that I don't know if you'll enjoy, but you'll definitely have interesting takes on. So basically, meme culture is very simple. I see something funny, I take an image from pop culture or internet culture, and I add funny pretext to it. So it's the idea, the muse, and juxtaposition that ends into memes. And the biggest thing about it is that it's existent in bulk. Like, there's so many memes that there is no way you could consume that much information in such a little time. For example, I follow I think 50,000, 60,000 pages.
My God.
Yeah.
You have time to do all this.
No. I don't have any time to do this. I break zero ground on them, but I follow all of them. I know about them. So we have an interesting divide in the meme culture by generation. There's the blue pill arc and the red pill arc. And blue pill here is not aware of the truth or unaware of the truth. Red pill is aware of the truth. And accordingly, the internet divides people. The people on the older scale of the blue pill are the boomers. Comes from baby boomers, as you would have assumed. And on the top of it are zoomers, which is the younger kids, like 18-year-olds.
Millennials.
Not millennials are in the middle.
Where are they?
Between
the boomers and the younger generation.
Yeah, right in the middle. For some reason, Gen X have been erased from this.
Okay.
I think that's because they're our parents. They're never a part of this conversation. But at the same time, they're in the middle. The top end of it are 12-year-olds on the internet. So they're Zoomers. My generation is like the first of the Zoomers.
Okay.
And what? I'm young. Shut up. Stop coughing. And then from the millennials, the red pill arc starts, which is the doomers and the bloomers. Basically, people who know the truth and now are depressed because they think their life doesn't mean anything. And then boomers who are
happy that they're condemned to be free.
Wow, wonderful. Ah, such a young age and such a deep philosophy. Socrates would be proud of, because I would like to quote here in the same vein that Socrates used to say that, I'll quote in the Greek what he used to say was, hen vida hoti uden vida. And the translation into English is, hen vida hoti is, I know one thing. And uden vida, I know nothing. But your bloomers and zoomers and doomers, whatever, they seem to be very sure about what they know. And they know only one thing, that life has no meaning.
Yeah, they know only one thing.
That's quite an amount of wisdom, I must say, achieved at such a young age.
No, I mean, the one parameter that I have understood on the internet from being there for about 10 years of my life is that being condescending is an essential.
Okay.
Whether you're right or not, that's not important. Nobody cares.
I see.
Yeah, all you have to do is be very condescending about your opinion, and you'll be celebrated.
And patronizing as well, apart from condescending.
Definitely.
Yeah, it has to be.
It has to be.
My God. My God. Okay, please.
So, like, the entire crux of it is that usually what we do is we make up these insults in internet slang, and then we bring it into the real world. The interesting pattern I see here is that the more people catch up, the more internet slang evolves. So, for example, there was a time when everybody used to say bro. Now, bro's gone out of style because that's not cool anymore. Now, the that's in is like bre. Yeah,
Bre.
Yeah, bre.
So what is the, now I would use the word neologism. Some of your learned and highly educated and wise audience must have heard the term neologism.
Some of them might.
Some of them might. In case they have not, for those who have not. Neologism is the way a new word is formed. The word which was not in existence, for example, user-friendly.
Yeah.
This expression was not there in pre-computer or pre-internet era. But perhaps the exigency of computer language and the users, they brought this word user-friendly.
Yeah.
Which has absolutely no grammatical sanction from Oxford Dictionary. But as they say, the force of use persuaded the Oxford Dictionary to include it in the dictionary as a neologism. And like that, there are many examples you would also find.
Yeah, I mean, the latest neologism that the meme community is pushing to be included in the Oxford Dictionary is a word called yeet.
Okay. How do you spell it?
Y-E-E-T.
Y-E-E-T-E.
Yeet. Yeah, yeet.
No.
Y-E-E-T.
Ends with T.
Yeah, ends with T.
Y-E-E-T. Yeah,
Yeah,
yeet.
yeet. And actually, nobody's sure what it means. We use it in the context of an explosion. We use it in the context of throwing somebody off a building. And we use it in the context of dunking on somebody in basketball.
Okay.
Those are the three uses that I'm familiar with. But that's how vague language has gotten so far. And
Is it exclamation or exclamatory word?
sometimes it is, yeah.
Because, and you are aware that I always used to insist on knowing the part of speech of that particular word, whether it's a noun or adjective or adverb.
Sometimes it's an explanation, sometimes it's a verb.
It's a verb.
Yeah, so I yeeted on those boys is a regular use of the same.
Okay. Conveying the meaning, any of these three.
Yeah, like I owned that discussion, basically.
Okay.
Like I was in a debate with my friend and I destroyed them in that debate.
Okay.
So I yeeted on that boy.
So we normally say, sir or madam, you killed it.
Yeah.
That kind of a meaning.
Yeah.
And we also believe in this kind of violent words. Yeah.
And well, I think we're at the 30-minute mark. This is a good note to end it at. Thank you so much for doing this with us, sir.
My pleasure. My pleasure.
Thank you.
Okay, my children, that's all I have for you this week. Well, that's episode 49 for you. Make sure to subscribe to me on YouTube, follow us on Spotify, Apple Music, wherever you're getting this podcast, and use all your strength to listen to this podcast, I guess. Today's was one of my more nicer episodes, I would suggest. Uh, I will be doing more interviews from now on, now that a lot of my audience has requested that. And we'll see where that goes. I hope you check out the YouTube video that I shot about musings about memes. Not shot, but edited and put up. It's a project that's really close to mine. I really hope you check it out and that you like it. So that's that, and I'll see you next time.